I'm very excited and happy to be here since it's an honor to have the possibility to express a few thoughts about the criminal policy in Romania as an overview of the criminal legal regulation. Practically, I will address you, let's say, my point of view at this moment, because our legislation is constantly changing with the speed and velocity that is not required for a criminal law provision, unfortunately. So I will present not an exhaustive and absolute overview, but a personal view of the criminal regulation in Romania today. I will have only 80 slides, so until 7 in the evening we can talk about the presentation. And then we can go directly to dinner. If not, I will refrain myself to the 15 minutes that I have the permission to speak. And first of all, let me properly start. Dear Director of Ferenc Mádl Institute, dear Dean Chuck Chila of Faculty of Law from Miskolc. Since I feel like home in Hungary, I will say dear colleagues from abroad, dear colleagues from Hungary. Many thanks for the opportunity to present a few thoughts of our, let's say, picture as it's presenting to you at this moment. The history does not start really with the code in 1938, it started previously, but that code is the element of reference whenever we are speaking about the evolution of criminal law in Romania. After the moments of 1989, we have tried to adapt our legislation in the sense that we found out that the old regulation is not valid anymore, and we try to make and to construct certain steps in order to have, let's say, a more updated criminal law regulation. As you can see on the slides, I have pointed out several of these steps. The most important would be, the first one would be Law 140 from 96, when we, let's say, established the same legal treatment for public and private property in Romania. Also, we introduced the audio-video recordings in the criminal procedure as a mean of proof. Furthermore, there was a landmark in 2003 when the prosecutor did lose its right to decide the arrest as a preventive measure due to the decision of the European Court of Human Rights. In 2004, we had an odd happening. I mean, we had a new penal code adopted by the parliament, but that code did not enter even 1 hour into force because it was repealed a few years ago. It was only, let's say, an exercise from the political government of that time, in the sense that they wanted to have each justice minister wanted to have its own code. So that was only an attempt, let's say. In 2010, we had a small effective reform, and it was intended to reform the justice in the sense that to bring more effectiveness, and in this regard, the procedure of admitting the guilt was introduced. Also, were introduced the first step in considering the plea bargaining procedure. If we are moving further, why was present the need for a new penal code? Of course, I have pointed out a few reasons: the repealing of some criminalization text from the special legislation, the elimination of the unnecessary overlap of some texts that protected the same social values, adapting the punishments, of course, decriminalization of certain facts provided in special legislation, and to observe the principle of minimum intervention. I have to say also, in addition, that the procedure that gave birth to the criminal code and criminal procedure code was not entirely 100% democratic, in the sense that they were adopted, all these codes were adopted through a speedy procedure in the parliament. We have a speedy procedure that is saying that the government can engage, let's say, its responsibility, and the members of the parliament cannot amend the text. They can only take down the government through a censor motion, and the other possibility there is no possibility effectively to change the text once is submitted for adoption in this speedy procedure. That was the case for the penal code. That was the case also for the criminal procedure code. And we can say that, I can say, at least, that it was a political decision to adopt them in that very text, in that very form, at that very moment. Of course, we had to adopt a new code, but probably not all the institutions were as it should have been at that moment. I have pointed out the main legal sources as regarding criminal law in Romania. The code is actually from 2009, adopted by the parliament, and 2010, the criminal procedure code, but they entered into force only in 2014. In this period, they were subject to a lot of amendments. So we have a law, we had the law that was intended to put into force, to transfer into force the provision from 2019 and 2010. So we had another two laws that were, let's say, giving the necessary legal power to those two codes. A main actor was in this process the Constitutional Court. The Constitutional Court acted as a veritable, an actual negative legislator, as you will see in the next slides. I mean, it's not the purpose of a Constitutional Court to act in this regard, but since the Romanian Parliament did not do its job, more text remain void of legal effects due to the decision of Constitutional Court. The general principle, legality of criminalization and legality of criminal sections, I think that all of our codes do have it. It was not so expressly emphasized in the previous regulation. We have a new definition of the criminal offense with the 4 conditions to be provided by the law: should be perpetrated with guilt, should be unjustified, and imputable to the person who committed it. From 2006, we have the criminal responsibility of legal persons, of juridical entities. And as regarding the punishment system, we have penalties, educational measures, and which are enforced against juvenile offenders, and safety measures. As regarding the life imprisonment, practically it's not a life imprisonment in Romania, since giving the age after 65 years of age, the offender can be subject to parole. And he or she can be subject to parole also in the case that the sentence served reached the period of 30 years. So after 30 years, he or she can be subject to parole. It's not mandatory to grant the parole, but it's a practice, let's say, it's a jurisprudence in that matter favorable to the offenders. We have 2+1 novelties. We have the waiver of sentence and postponement of the enforcing of the sentence as newly introduced alternative sanctions. And we have also the suspension of the execution of the sentence under supervision. This was also in the previous regulation, but the new regulation made it more strictly, giving the two choices newly introduced. And in the first years after adopting the code, they were not used by the judges. Now they are used, and they are effective. They are effective because in the first case, when it's about the waiver of the sentence, it's about criminal offenses that are punished up to 5 years imprisonment. And in the second alternative sanction, the postponement of the enforcing of the sentence, the general condition is to have criminal offenses that are punished up to 7 years. That means that they could be effective, and they are used nowadays by the courts on a great scale. I have underlined also some points in the special part of the criminal law as regarding the patrimonial offenses. There was a rather big change in redefining the theft and qualified aggravated theft, also the robbery. And they introduced, the law did introduce new criminal offenses. Part of them were previously regulated by special laws, and now they were transposed into the criminal code, as it should be the case in this area, because if you have one regulation, then it should be precise and effective and clear. It should be clear. We have introduced a number of new offenses, as the abuse of trust by fraud of creditors, and also diversion of public auctions that were not regulated before, but the new realities of public, let's say, public acquisitions and were forcing us to move also on that direction. As regarding the duty offenses, we had a big discussion because, you know, I think it's common knowledge that we faced a lot of dilemmas as regarding corruption in Romania. So we had the special law in 2000, then the special law was changed. Now let's say the wording and the text are more systematic, regulated, because we have the offenses into the criminal code, not in some special laws and so on. And we have the corruption offenses and the duty offenses now in the new criminal code. Also remain some duty offenses in the law 78 from 2000, but the core of the regulation is now included in the criminal code. Also, I will get back to the decision of the Constitutional Court, because in 2016, that red mark decision said something like this: the law is not clear and it's unconstitutional. It's not clear because it refers to a defective fulfilling of obligation, of duty obligation, without saying where can you find that duty or that duties. But since 2016 until this moment, the law has not been amended. So now we have the regulation in one foot, let's say, because only you can address this matter only if you find in a law the duties that a public servant should perform. And you can imagine that it's not the case in all situations. If I have the time, okay. As regarding the criminal procedure, we have verbally and writingly expressed those principles that I have wrote into the slide: legality, separation of judicial functions, presumption on innocence. Of course, we had it before, but not in this wording. In dubio pro reo, finding the truth, ne bis in idem, was not before, it is now. Obligation to initiate and exercise criminal proceedings, except certain cases when the principle of opportunity could intervene, that we did not have before. The fair character and reasonable term of the criminal trial, and the right to liberty and security during the criminal proceedings. Some of them were before, some of them were, let's say, more underlined and described in the new regulation. We have the stages. I have presented the stages of the criminal procedures. We have the prosecutor office, who supervise the investigation, even the investigation made by the policeman or the prosecutors. Then we have the judge, special appointed judge for rights and liberties, who will decide about the indictment, if it's valid from legally point of view, in the preliminary chamber procedure. Also, the preliminary chamber procedure will decide about the preventive measures. And then, after the preliminary chamber judge will decide about the legality and the indictment can consider legal, then the actual trial will start. As I told you, we have the possibility of the diversion, in the sense that if we are speaking about a criminal offense punishable with imprisonment for maximum 7 years, then the prosecutor can decide if they are moving further or not. If they are moving further, giving some arguments as presented in the text of the law. It's not an arbitrary decision. If the criteria are not met, then the judge will not validate the prosecutor's decision. In the second or final part of my presentation, I have pointed out a few concrete aspects. We had the problem with the misrepresentation and computer fraud. Computer fraud recently introduced into the Criminal Code. We had the special law, of course, because we are the signatory part of the Cybercrime Convention from Budapest. But there was a problem in qualifying the act as misrepresentation or computer fraud when it was perpetrated to public announcement. We have the site called OLX. I don't know if it exists in other countries, but through that site, there were a lot of, let's say, patrimonial damage carried out. And the highest court of Romania established through a decision that the publication of fictitious online announcement that resulted in a damage without intervening on the computer system or on the computer data processed by it, achieves the typical condition of the crime of deception or misrepresentation, as that may be the case in the Article 254. The stake, as I presented in the first paragraph, is the punishment. The maximum punishment for misrepresentation is less than for the computer fraud. So that was the starting point of this debate. Other one would be the dispute, and never-ending dispute, between constitutional court, national courts, and EU law. We had a lot of debates on that matter. One of the debates started from the fact that the Secret Service could gather evidence in ordinary criminal trial, especially recordings. And at some point, the Constitutional Court decided it's not a constitutional procedure and declared void those provisions. And you can imagine what should have happened. I mean, the police started to initiate procedure in order to have its own recording and supervising technical office. We did not have it before. Only the Secret Service sees, I don't know how many there are, only the Secret Services did deal with that problem. And starting from that point, a number of recordings present in the file were taken out. After a while, a few judges asked the European Court of Justice what prevails, the decision of Constitutional Court or the decision of EU law. Because in their opinion, the decision of Constitutional Court of Romania came in contradiction with the EU law. And the EU law said, do whatever you want, something like this, in the sense that it declared the supremacy of EU law. Who does not know about the supremacy of EU law? Of course, the European Court could not intervene directly into the file, of course. And it remained at the, let's say, decision of the judge to let the recordings in the file or to take them out physically. And some judges do that, some judges do not do that. The problem is that under the Romanian law, if you do not, let's say, observe the decision of Constitutional Court, it's a disciplinary, could be subject to disciplinary investigation and sanction. And now, from my opinion, the highest court in Romania, High Court of Cassation, should decide how to interpret the decision of European Court, in the sense that the whole country should, the whole judges, all the judges from the country should act in one direction, not one should take out the recordings, one should let them and trial and issue the solution, the decision based on that. I mean, it's rather crazy. We had this case also in Oradea, in my hometown, and there are also a lot of cases in Bucharest which involves a lot of stars, let's say, political stars, of course. And that's why the discussion is so amplified. I will move further. As regarding the sexual offenses, we do have a problem. We do have a problem because we cannot investigate them effectively, and the solution was to extend the statute of limitation until. So we do not have any statute of limitation as regarding criminal sexual offenses against minors, about juveniles. I don't know if that is the best approach. Even the High Council of Magistrates did, let's say, took steps in order to investigate the problem, and we have a report last year was published, and it pointed out a few, let's say, problems that we have to deal with. And another thing is that even in criminal law trials, we did not, in Romania, there was no obligation for the judge to motivate the decision. He or she could pass the decision without the reasoning present. That was changed also initially by the Constitutional Court and then by a law which was adopted in a speedy procedure. And as a result of that law, when a criminal law judge should pass the sentence should be passed altogether with the decision and the reasoning. So, as is the case, I know in Hungary, because I was in some courts in Hungary, of course, as invited guest, not, not in other capacity. Of course. That was a significant change because no one wanted to write the reasoning because it was, let's say, comfortable, issue the decision, and the problem was practical. Problem was that the offender was imprisoned, and there was no decision, complete decision about why he was imprisoned. That is not, I don't know, not correct from any point of view. As regarding statute of limitation, the last problem I want to underline, we had a special statute of limitation that said mainly you can prolong the period with 50%. If you do one investigation act during this period. So practically it was not one period, but 1.5 periods. And based on that, the files were not investigated, were not trialed, and waiting and postponed from one month to another. Now, the Constitutional Court said that is not constitutional, because in many cases that act which did prolong the period were not communicated to the parties, so you do not know what happened. Anyway, in this moment, there are a lot of files presently in the phase of trial that will be seized due to that decision, which is very recent, as you can see, because the statute of limitation was fulfilled previously in that case. And unfortunately, the criminal liability will not be activated. Thank you for your attention. Köszönöm a figyelmet.